In this lecture, we'll briefly reconsider the concept of judicial review in South African law, and we'll consider the grounds on which courts can judicially review administrative action in terms of Section 6 Sub 2 of the Promotion of Administrative Justice Act 3 of 2000, or PAJA. These grounds will be applicable when administrative action does not adhere to the standards of administrative justice as provided for in Section 33 of the Constitution. These standards or requirements for valid administrative action are lawfulness, fairness, and reasonableness. So we know that in this course we deal with cases where the administrative law might apply. Now, the first thing we have to do whenever we read an administrative law case is work out what type of conduct is being performed. The type of conduct then determines the basis on which the courts will judicially review that conduct. And once we know the type of conduct, we can then work out which standards are applicable in relation to the scrutiny of that conduct. In other words, which review grounds apply. So unpacking that a bit more, remember we have said that every case involves some or other kind of conduct. The first thing we will do is work out if the conduct amounts to public power or private power. If the conduct amounts to public power, which it most often will in this course, then we have to consider whether that public power amounts to administrative action, as defined in PAJA, or if it falls outside of the definition of administrative action in PAJA. If the conduct amounts to administrative action, then PAJA review grounds will apply as grounds on which we can scrutinize that administrative action. If the conduct does not amount to administrative action but is public power, then legality grounds of review will apply. If the conduct is private power, well then common law review grounds might apply if the power mimics public power. So having recapped this, remember we've spent the last few weeks working out when conduct will be administrative action. And that involved understanding that conduct that is administrative action involves a decision of an administrative nature, of a public nature, that has a particular impact on rights. And now that we know what kind of conduct is susceptible to review in terms of PAJA and is subject to the standards of administrative law under Section 33 of the Constitution, we need to understand what the standards are all about. So the standards are that administrative action must be lawful, fair, and reasonable. We're going to unpack these standards in the next few weeks. PAJA tells us that conduct that is administrative action and fails to adhere to these standards will be reviewable on a number of grounds set out in Section 6 Sub 2 of PAJA. And they'll be reviewable by a court in judicial review proceedings. So let's recap then on what judicial review proceedings are. Now, we know that almost every administrative law case involves judicial review. Quino's book points out that the courts are the primary mechanism of regulating administrative action through judicial oversight of the work that administrators perform in the running of the state. Now, courts are empowered to interfere with the work of the administration when a ground of review exists. In other words, when conduct is unlawful, unfair, or unreasonable. When courts perform this review function, They need to ensure that the administration keeps within its mandate. Remember, I've said they need to stay within their lane. And the courts ensure that the administration exercises its function in a manner that complies with the law. So, courts in judicial review proceedings don't generally look at whether an administrator took the correct decision, so they don't engage in an appeal function. Instead, courts look at the way in which a decision was taken, whether the decision was taken in a manner consistent with the demands of lawfulness, fairness, and reasonableness. This is a review function. Judicial review, then, is a specific dispute resolution procedure that developed under the common law, in terms of which courts scrutinize administrative action against the rules or requirements or standards of administrative law. Judicial review is now constitutionally sanctioned by Section 33 of the Constitution. When public power is reviewed against administrative law's standards, administrative law operates as an incident of the separation of powers, pursuant to which the courts regulate and control the power of the other branches of government in the running of the state. This was acknowledged in the pharmaceutical manufacturer's case at paragraphs 44 to 45. Now we know that conduct that doesn't amount to administrative action but is still public power is also subject to judicial review. In that instance, judicial review occurs as a way to pursue the rule of law provided for in Section 1 sub C of the Constitution, in terms of what is known as the principle of legality. And the principle of legality requires that conduct must be lawful and rational. Now, obviously, there is some overlap between the requirements of administrative justice and the requirements of legality. However, when conduct is administrative action, the principle of subsidiarity tells us that we must review conduct in terms of PAJA, which gives effect to Section 33 of the Constitution, and not rely on legality in review proceedings. So now let's turn to have a quick look at the grounds of review in terms of Section 6, sub 2 of PAJA. So hopefully you've all had a look at Section 6, sub 2 of PAJA. It sets out the grounds on which administrative action under PAJA can be scrutinized or reviewed. Conduct can often be reviewed on more than one ground, and usually someone who is challenging administrative action will try and find as many things wrong with the conduct as possible to raise as many grounds of review as may be applicable. Now, we will be working through a number of the grounds in the next few weeks. But as a starting point, we need to recognize that Section 6 sub 2 doesn't really follow a logical structure. The grounds of review are all jumbled up, addressing the three main standards or requirements of valid administrative action: lawfulness, fairness, and reasonableness. And there's also a lot of overlap amongst them. Remember also that these grounds of review codify the grounds of review developed under the common law to a great extent. And they even then go beyond what the common law allowed as bases for judicial review. What that means is that we can, to the extent at least that the grounds of review codify those developed under the common law, we can look to the pre-PAJA case law to help us understand how the relevant grounds of review should work. And indeed, many of the cases that I ask you to look at in the coming weeks are cases that emerge from the common law era. Now, why did I put this picture of a lady looking at a toilet for this slide? Well, We know that service delivery is a function of the running of the state, the administration of the state. And provision of sanitation services is one of those services that is to be provided in the running of the state, particularly for poor and vulnerable people. And what has happened in a number of municipalities is that instead of providing proper municipal services and sanitation, municipalities have provided outdoor or open toilets, such as the one depicted in the graphic. Now, obviously, this kind of conduct is outside of what relevant laws require, particularly the constitutional right to this kind of basic service. Often we've experienced in the case law that these kinds of toilets have been provided in circumstances that are therefore unlawful, but also in the absence of public participation about what the communities affected need. And that means that a fair process wasn't followed and the decisions were not the best decisions that could have been reached. Finally, the decisions are also not reasonable. Providing sanitation outside somebody's house is not reasonable provision of sanitation. So what the courts have found is that this kind of behavior is reviewable or subject to scrutiny on the grounds of unlawfulness, unfairness, and unreasonableness. The other reason why I put this toilet picture is because it's a memorable example of maladministration. It also is reflective of how the judicial review grounds in section 6.2 of PAJA are very jumbled up, and you can draw your own conclusions on that example or reason for including this picture. Okay, so let's then turn to unpack these grounds of review in a bit more detail. So we know that there are standards for just administrative action, and when those standards are not met, there are a number of grounds on which we can challenge the failure to meet those standards. So section 33 tells us the requirements or standards for just administrative action, or for administrative justice, which is again what this course is all about. The first thing is that in order to be just, administrative action must be lawful. The requirement of lawfulness is simply that administrative action must adhere to the rule of law. In other words, everyone, including the state, is subject to the law, and all public power is derived from the law. This principle of the rule of law implies two things for the administrative law. An administrator may only act if she has the authority in terms of the law to do so. And when the administrator does have authority in terms of the law, she must exercise her powers as the law prescribes. In short, lawfulness requires that administrators act within their powers. To use the Latin phrases, administrators must act intra vires rather than ultra vires, which would be outside of the law. The second standard for just administrative action is that of procedural fairness. Now, in short, this requires that administrators must always exercise their powers in a fair manner. In the case law, two basic requirements of fairness have developed to date. First, fairness requires that administrators follow a fair process in the exercise of their powers. The procedural fairness referred to in the Constitution. A fair process entails that administrators allow those who are affected by decisions to participate in those decisions so that they can influence the outcome and protect their interests. That is, administrators must give affected persons notice of impending decisions and an opportunity to make representations. and administrators must then take those representations into account in reaching their decisions. Once a decision has been taken, that decision must be brought to the attention of affected parties, and affected parties must be informed of their rights to request reasons for the decision and of any remedies at their disposal. The second requirement of fairness involves a prohibition against bias or prejudgment of a matter. That is, administrators are required to approach their decisions with an open mind, free from the influence of own interest, prejudice, assumptions, etc. The third requirement or standard for just administrative action is that it must be reasonable. Reasonableness is a relatively new addition to the administrative law, and it really expresses the idea of accountability. So reasonableness entails in broad terms that administrators must be able to account for their decisions, as in explain or justify them. In the first place, this means that administrators must be able to justify the decisions in light of the information on the basis of which they were taken. This means that the decisions are rational. There's a rational link between the facts and the decision taken based on those facts. Secondly, reasonableness entails that administrators should be able to justify their decisions in light of the purpose of the decision. They must be able to show that the decision made can achieve the purpose for which it was taken. This is a requirement under reasonableness that a decision must be effective. In the third place, a decision will be reasonable if an administrator can justify the decision in light of its adverse consequences. In other words, administrators must be able to show that the adverse consequences of their decisions are discounted by the advantages thereof for the public interest, a requirement of proportionality. Now, reasonableness is applied in a variable fashion to administrative decision making. Decisions must always be rational, they must mostly be effective, and they must sometimes be proportional. And we'll study this in more detail when we look at reasonableness later on in the semester. Now, of course, over and above imposing standards for just administrative action, Section 33 requires that reasons must be provided for administrative action on request. Now, the issue of reasons is dealt with not in the grounds of review under Section 6.2 of PAJA, but in Section 5 of PAJA, and will be looked at separately once we've addressed the grounds of review. The important thing to note at this stage is to have a high-level understanding of what the three requirements for valid administrative action or just administrative action are, and to know that when conduct is inconsistent with these requirements for just or valid administrative action, it will be capable of being taken on review in terms of Section 6 sub 2 of PAJA. So let's have a quick look at Section 6 sub 2 of PAJA. Section 6 sub 2 lists a number of circumstances in which conduct can be taken on judicial review. Now, as I said, the list is very jumbled up and isn't always that clear. There's a lot of also overlap of the different grounds of review. But let's take a moment to consider which of the grounds of review relate to lawfulness, which relate to fairness, and which relate to reasonableness, respectively. So the first ground of review that's provided for is that courts may review administrative action if the administrator who took the decision was not authorized to do so by the empowering provision. Now, This ground of review clearly relates to the requirement that administrative action must be lawful. This is because lawfulness requires that administrators must act within the powers prescribed by law. So this ground tells us that an administrator's conduct will be reviewable if the administrator acts without authority or outside of the powers prescribed to her by law. The same reasoning applies to section 6 sub 2 sub a sub Roman numeral 2. When an administrator acts under a delegation of power not authorized by the empowering provision, again, they don't have the power to do what they are doing. The third requirement in 6 sub 2 sub a sub Roman numeral 3, or rather ground of review, not requirement, provides that an administrator's conduct may be reviewable if the administrator was biased or reasonably suspected of bias. Now, this ground of review relates to fairness. Here, an administrator fails to follow a fair process when she is biased and has prejudged the outcome of a matter. The next ground of review in section 6 sub 2 is subsection B, which says that a court may review administrative action if a mandatory and material procedure or condition prescribed by an empowering provision was not complied with. This ground of review concerns lawfulness, because an administrator who does not comply with procedures and conditions prescribed by an empowering provision will act outside of the powers prescribed to her by law. The next ground of review, section 6 sub 2 sub c, provides that administrative action will be reviewable in courts if the action was not procedurally fair. Now, this clearly relates to procedural fairness, the requirement that administrative action must be fair. So, this ground of review will apply if an administrator acts in a biased manner or if the administrator fails to follow a fair process. The next ground of review entails that a court may review administrative action when the action was materially influenced by an error of law. This ground relates to lawfulness, since where an administrator makes an error in her interpretation of the law that authorizes her to act, and her actions are based on this error of interpretation, as opposed to what the relevant law actually requires, she then acts outside of the power prescribed to her by the relevant law. Section 6 sub 2 sub e contains a number of grounds of review. The first one is that administrative action will be reviewable if taken for a reason not authorized by the empowering provision. This ground of review concerns lawfulness, since an administrator who acts for a reason not authorized by the empowering provision acts outside of the powers conferred on her by the relevant empowering provision. So a provision will often say, you must act for purpose X or for reason Y. If the administrator then acts for purpose or reason Z, he or she acts unlawfully, outside of what the provision requires. Administrative action is also reviewable if the conduct is performed for an ulterior purpose or motive. This ground of review concerns lawfulness, since an administrator must exercise power, again, for the purpose for which the powers were conferred, and not for some hidden or bad purpose, such as fraud or corruption. Conduct will also be reviewable if it is taken or if it's performed because irrelevant considerations were taken into account or relevant considerations were not considered. Now, this ground of review also relates to lawfulness. Often an empowering provision will tell an administrator what considerations ought to be taken into account when making a decision. Now, where this is the case and an administrator fails to take into account a relevant consideration or takes into account an irrelevant consideration, she acts outside of the power conferred on her, where the consideration or failure to take something into account materially influences her decision. Section 6 sub 2 sub E Roman numeral 4 provides that administrative action will be reviewable if it's taken because of the unwarranted or unauthorized dictates of another person or body. This ground of review also concerns lawfulness. Where a decision is taken because somebody else influences that decision as opposed to the law informing what the decision should be, then the decision is taken outside of what the law requires. Also, it's a basic principle that the responsibility for exercising power rests with the authorized body or person and no one else. So if the authorized body or person is being dictated to by someone else, then the authorized body or person is acting unlawfully. They are abdicating their responsibility or passing the buck. The last two provisions in section 6 sub 2 sub E also relate to lawfulness. When conduct is taken in bad faith or arbitrarily or capriciously, then it is taken in a manner that is not lawful. Lawful conduct is taken in good faith. It is not arbitrary or capricious. There are just a few more grounds of review listed that we can consider. Most of them you'll have seen relate so far to lawfulness, but a couple have related to procedural fairness so far. The next ground of review in section 6 sub 2 sub F says that administrative action will be reviewable when the action itself contravenes a law or is not authorized by the empowering provision. Now, this ground of review relates to lawfulness. A decision that contravenes a law or is not authorized will obviously be unlawful. It will be taken in a manner outside of the power conferred on the administrator. Section 6.2f Roman numeral 2 concerns the review of administrative action when it is not rational. This ground of review relates to reasonableness. Rationality is an aspect of reasonableness. Reasonableness is, of course, greater than, but includes rationality, at least. Now, a decision that is not rationally connected to the purpose for which it's taken, the purpose of the empowering provision, the information before the administrator, or the reasons given for it, will amount to a decision that cannot be justified by the administrator and will therefore be unreasonable. The second last ground of review relates to a failure to take a decision. Section 6, sub 2, sub G provides that administrative action will be reviewable when the action concerned consists of a failure to take a decision. Now, this ground of review relates to lawfulness. This is because powers conferred on administrators are typically accompanied by an implied duty to exercise the power. A failure to exercise the power will amount to conduct outside of what is required by law. The last main ground of review is in section 6 sub 2 sub H of PAJA. It provides that a court may review administrative action when the conduct is so unreasonable that no reasonable person could have exercised the power or performed the function. Now, this ground of review clearly concerns reasonableness. A decision will be reasonable not if it is perfect or correct in the court's eyes. A range of possible decisions might be reasonable in any given set of circumstances. As long as it falls within a reasonable range of decisions, then it will be one that a reasonable decision maker could have made. If it falls outside of a range of what is reasonable, then conduct will be reviewable in terms of Section 6, sub 2, sub H. Now, Section 6, sub 2, sub I tells us that the review grounds listed in Section 6, sub 2 are not a closed list. Other unlawful conduct not expressly listed can also be reviewable. So review grounds provided for in other statutes could be covered by this provision, and grounds that are developed under the common law but were not specifically listed in Section 6.2 could be covered. One of the examples is decisions that are vague, which are found to be reviewable on the grounds of being otherwise unlawful in terms of Section 6, sub 2, sub I. So those are all the grounds of review provided for in Section 6, sub 2, and now you know how they relate to the standards of administrative action as provided for in Section 33 of the Constitution. Next week, we will start to unpack some of these grounds of review in more detail. I will see you then.